I now give the floor to the representative of Sierra Leone, Mr. Sesai, to make his statement. You have the floor, sir.
Mr. President, distinguished members of the Tribunal, good morning. It is my distinct honor to appear before you today in my capacity as the Deputy Minister of Justice, representing the Republic of Sierra Leone in these historic proceedings. We appear before you for the first time because of the already significant impacts of climate change for my country and its people. Though the climate emergency poses the greatest threat to our planet and to this generation, there is simply no equity when it comes to managing its effects. This tribunal's advisory opinion is an opportunity to change that. Sierra Leone, located on the west coast of Africa, is among the lowest contributors of greenhouse gas emissions in the world. Yet, my country is also among the 10% of countries that are most vulnerable to climate change. Sierra Leone hopes that the tribunal will use the opinion not just to clarify state parties' obligations under the convention, but also to help strengthen the foundation for equitable solutions to the climate emergency. Members of the tribunal, starting with the legal framework, there can be no doubt that the two questions that the Commission of Small Island States and International Law have put to this tribunal in its request for an advisory opinion address fundamental issues that lie at the heart of modern international law. The tribunal is asked to clarify how UNCLOS obligations agreed upon more than 4 decades ago are aligned with the demands of the climate emergency the global community faces today. In answering those questions, taking into careful account the latest scientific consensus on climate change, the tribunal has an historic opportunity to make at least 3 fundamental contributions. First, to play a vital role in outlining not just how these obligations under the convention might be interpreted under international law, but also interpreted in a manner that shows appropriate sensitivity to the disproportionate impact of the climate emergency on developing countries such as ours. Second, the tribunal has an opportunity to set the historical record straight. For it is a fact that those most affected by climate-induced changes to the marine environment have contributed the least to the problem. Legal consequences must flow from this fact if we are really serious about addressing marine pollution and climate change more broadly. Finally, building on this last point, the tribunal could make clear that international law can play a meaningful role in offering solutions to address this practical problem. This will require paying due regard to the reality of differential capabilities of states to mitigate and adapt to the various harms caused by climate change. The reality that if we are to solve the climate challenge, those with the means must step up to their responsibilities. The reality that those who have not been industrialized and are still developing are essentially being asked to subsidize the polluters by being left to deal with the climate mess, not of their own making. Mr. President, these are among the important reasons why these advisory opinions are so important to Sierra Leone as a country. They are an opportunity for law and justice to be served, not just for Sierra Leone, but also for the many other developing countries in the global south that find themselves in a similar position. Developing countries from all regions which have contributed the least to the pollution of the marine environment and the pollution of the atmosphere are shouldering a disproportionate burden of the existential threats posed to our planet by the deleterious effects of climate change. The polluters who have produced most of the greenhouse gas emissions that got us where we are today reap the benefits while we, the non-polluters, pay and continue to pay the price. The polluters must pay. Mr. President, for Sierra Leone, the science is clear. The science is uncontested. It is this clear and uncontested science which makes our presence in these proceedings imperative. For us, the risks from human-induced climate change are particularly high. This is due to our particular geography as a low-lying state. In fact, the negative effects of climate change on the marine environment have already been keenly felt in Sierra Leone. The impacts are multiple. They range from rising seas to the forced displacement of our people inhabiting certain inlands and low-lying coastal areas to dramatic changes to our fisheries economy. Economically, the fisheries sector is an important facet of Sierra Leone's future growth. The industry provides food security and employment opportunities. In addition to generating substantial economic activity and providing a valuable source of export earnings, the fisheries sector represents a major lifeline for Sierra Leone as a recovering post-Civil War society to provide both sustenance and opportunities for its people. The harm that climate change is currently causing threatens to undo hard-fought progress that has been made thus far. Moreover, Sierra Leone has had to grapple with the impact of food security, particularly among rural households for decades. Fisheries are vital for food security. They are especially important to our poorest communities. Yet, climate change-induced ocean warming has contributed to an overall decrease in maximum catch potential. This has compounded the impacts from overfishing for some fish stocks. Mr. President, Sierra Leone is both particularly susceptible to climate change impacts and at the same time lacking in capacity to adapt to these impacts. Sadly, Sierra Leone is not alone. There are many Sierra Leones. Generally, coastal ecosystems in West Africa are among the most vulnerable to climate change because of extensive low-lying deltas exposed to sea level rise, erosion, saltwater intrusion, and flooding. Already, sea level rise has caused significant challenges to the livelihoods of our coastal inhabitants. Coastal erosion is taking place. The result is a shifting of the coastline, sometimes dramatically so. At a 1.5 degrees Celsius global temperature increase, among the principal hazards to ecosystems are continued sea level rise and increased frequency and magnitude of extreme sea level events that encroach on coastal human settlements and damage coastal infrastructure. There is a serious risk of committing low-lying coastal ecosystems to submergence and loss, and expanding land salinization with cascading risk to livelihoods, health, well-being, food, and water security. If no action is taken, a total of 26.4 kilometers of the Sierra Leonean coastline is estimated to be lost to the sea by the year 2050. Sea level rise is expected to affect almost 2.3 million Sierra Leoneans who are at risk of experiencing a 1 meter rise of the sea level along coastal areas. Already, in various parts of Sierra Leone, islands have fallen victim to sea level rise. For instance, inhabitants of Yelibuya Island have had to be relocated due to flooding and partial and permanent inundation. The human impact of the climate-related displacement of our people from their homes is immense. People lose their homes. People lose their livelihoods. People even lose memories of where they were born, of where they were raised, of where they started their own families. Generations of memories, generations of property, gone, with no hope for return or for recovery. Even worse, the science indicates that we are all approaching a point of no return. The marine environment, a shared resource, is especially susceptible to climate change and should therefore of special concern given and should therefore be of special concern given the significance of the oceans to the health of our planet as a whole. Mr. President, I want to be clear. We are not helpless, nor are we resting on our laurels. Sierra Leone has already undertaken various measures to mitigate and adapt to the deleterious effects of climate change on our country and on our people. We have taken significant steps to implement various projects over many years. But the stark reality is that as a developing state, Sierra Leone has limited resources. We also have limited technological capacity to meet all the increasing demands of the climate problem. Finance is a particularly important barrier for government programs generally and for ocean health, governance, and adaptation to climate change for Sierra Leone. What we put in climate-related mitigation is food in the mouths of our children. What we put in climate-related mitigation is money we do not use to educate our children. What we put in climate-related mitigation is money we do not use to nurse our sick children back to good health. We therefore believe that the obligation to protect and preserve the marine environment under the Convention must be understood in the context of state obligations under general international law and consistent with principles of equitable burden sharing. We further believe that meaningful progress for the sake of all humanity requires strong international cooperation, certainly more cooperation than we have now. Stronger international cooperation means providing sufficient financial and technical assistance to developing states consistent with the relevant provisions of the Convention, including the common but differentiated responsibilities principle. Sierra Leone is proud to be among one of many African states to UNCLOS to participate in these proceedings. We stand here as the only country from the west coast of the continent to participate. Our hope is that this process provides greater clarity on state party obligations in relation to the legal questions posed. Our hope is that this tribunal gives meaningful content to the common but differentiated responsible principle and the technical assistance provisions under the Convention. Our hope is that the tribunal recognizes the vital importance of the marine environment as a shared global resource which needs strong protection from pollution, whether from oceanic sources or from land-based sources. Sierra Leone acknowledges that the tribunal has a significant task ahead of it. We are confident that this tribunal, whose contributions to the interpretation of the Convention have been remarkable, will continue to play its critical role as a principal interpreter and guardian of the Convention in accordance with its founding instruments and existing international law. Sierra Leone very much hopes that its own arguments and those by other states will assist the tribunal in answering the questions before it. It should ultimately lead the tribunal to pronounce itself clearly on the legal obligations that may lead to the actual prevention, reduction, and control of marine pollution. Mr. President, distinguished members of the tribunal, I am grateful for your kind attention. And in conclusion, I would like now to request that you invite Professor Dere Tladi to the podium. I thank you.
Thank you, Mr. Sesai. I now give the floor to Mr. Tladi to make his statement. You have the floor, sir.
Mr. President, distinguished members of the tribunal, it is an honor for me to appear before you today in these proceedings on behalf of the Republic of Sierra Leone On the question of jurisdiction, Sierra Leone wishes only to recall its written submission that the tribunal indeed has jurisdiction and should exercise it. So my task today is really only twofold. First, with a view to assisting the tribunal, I wish to set out the proper approach to interpreting the obligations under the Law of the Sea Convention. My second task will be to address the obligations of due diligence, the overarching obligations contained in Articles 192 and 194 of the Convention, and which is relevant to both questions A and B. On the basis of the rules of interpretation that I will momentarily set out, Sierra Leone believes that the specific content of this obligation is to be informed by relevant international rules and standards, as well as scientific evidence. It effectively requires states to adopt necessary measures, individually and collectively, to limit the increase in global average temperatures to under 1.5 degrees Celsius above pre-industrial level. I will thereafter hand over to Professor Jallow, who will argue that the obligation of due diligence necessarily encompasses the precautionary principle, obliging states to act even in the face of scientific uncertainty, whatever scientific uncertainty there may still be. I turn now to the question of the interpretation of the Law of the Sea Convention. The Convention, the Constitution of the Ocean, is not only comprehensive, it is also flexible, which allows it to adapt to new developments and scientific knowledge. It was Judge Lucky that observed in the Sub-Regional Fisheries Commission advisory opinion that the Convention is a living instrument which grows and adapts to changing circumstances. It is in part because of the rules of interpretation that it is able to do so, and it is for that reason that we wish to spend some time on these rules. It is the case that the words climate change do not appear in the Convention. This, of course, is because the international community did not have the same awareness of climate change and its consequences, including impact on the marine environment, that we have today. Nonetheless, we shall argue that a proper interpretation of the Convention, relying on the normal rules of interpretation, mandates the consideration of existing instruments, principles, and scientific developments. The rules of interpretation, of course, are to be found in the Vienna Convention on the Law of Treaties, which I think we all agree reflects customary international law. The general rule, which is expressed in Article 31, paragraph 1, provides that a treaty is to be interpreted in good faith, in accordance with the ordinary meaning of the words in the treaty, in their context, and in light of that treaty's object and purpose. Now, in paragraphs 46 to 49 of our written submissions, we have showed how the ordinary meaning of the words in the Convention, in their context, and in light of the Convention's object and purpose, cover climate change-related impacts. We illustrated, just for example, that Article 1, Paragraph 1, Subparagraph 4 of the Convention, which defines pollution to the marine environment, must necessarily cover excess anthropogenic greenhouse gas emissions into the atmosphere, in part because pollution includes pollution from or through the atmosphere, as provided for in Article 12. We, in consequence, illustrated that the Convention requires states to prevent, reduce, and control marine pollution by inter alia taking measures to mitigate climate change. We note here in particular that the context would necessitate the consideration of available science and the continuously expanding human knowledge. And here the relevant context is Part 12 of UNCLOS, which anticipates that its provisions would be interpreted in light of exchanges in scientific information and data. It is our submission that this allows the content of such obligations to evolve with scientific developments which did not exist at the time the Convention was negotiated and adopted. Relevant in this regard, as many have noted, is the latest report of the Intergovernmental Panel on Climate Change, which is based on decades of observation and laboratory results. An argument has been made for a restrictive interpretation of Article 1, Paragraph 1, Subparagraph 4 of the Convention, which would exclude climate change impacts. With respect, Sierra Leone considers that such an approach would undermine the notion of the Convention as a living instrument. But more importantly, such an approach would not be in keeping with the ordinary meaning of the words of the Convention in their context and in light of its object and purpose, a point illustrated more fully in our written submissions. I pause here to add that in the view of Sierra Leone, the question is not whether the emissions of greenhouse gases constitute pollution under general international law or any other instrument. The question, rather, is whether greenhouse gas emissions may constitute pollution under the Law of the Sea Convention itself. Sierra Leone submits that under the ordinary meaning of the words of the Convention in their context and in light of its object and purpose, emissions of greenhouse gases into the atmosphere, which leads to deleterious effect on the marine environment, does amount to pollution within the meaning of the Convention. Thus, under the Convention, states parties are obliged to adopt measures to mitigate climate change. Moreover, in the discharge of its judicial functions. It is important to emphasize in this respect that the Tribunal, by giving content to broadly framed provisions in the Convention, would not be establishing new rules, but only describing the content of already existing obligations. With that legal framework in mind, Mr. President, I come now to the substance of the questions before you. The Tribunal is asked to set out specific obligations of states parties to the Convention, including Part 12, to prevent, reduce, and control pollution in the marine environment, and to protect and preserve the marine